Thank you for keeping up with me and watching all of these videos, because this is a key component of keeping you and your loved ones informed. It's very important to be informed during the process. Now, in the last section, we talked about a lawyer's duty that is set forth by the bar for keeping a client informed. We go above and beyond what the bar requires to keep people informed. And one of the things I did not mention in the last video that I'll just add in here is quite often we send jury instructions, copies of the probation statute, and sometimes even the rules of criminal procedure. So we're more than happy to keep you informed. However, there is a reciprocal duty that you owe us as your legal team, and these are some of the things that are part of that duty. Number one, first and foremost, you must do a fact pattern report. Now, if you're watching this and you have a loved one in jail, they still have to do a fact pattern report. Now, can they sit there and whip out their notebook and immediately start typing out their fact pattern report? Not at all. But what they can do is they can order from the commissary a pad and one of those jail pens. And a jail pen doesn't look anything like this one at all. As you can see, this pen's pretty firm. Well, jail pens are designed with security in mind, and I totally get it that they are a stabbing pain in the you-know-where trying to use, but it's critical that we have a fact pattern report. It's critical that you spend 4 days writing it, because we don't know what kind of evidence is in your head that we need to know about. And I always tell this story. My very first trial in 1990 involved a case where we picked a jury, and just before the trial started, my very first opening statement, my client goes, "Oh, Mr. Cobb, I forgot to tell you X. Is X important?" And I'm going, "Oh my God, X means you lose. Pray tell, John Doe, why did you not tell me X?" And he said something I'll never forget. He said, "I didn't know if it was important," and I kept forgetting. So when you're doing your fact pattern report, we want to know everything. Your clothing, other witnesses' clothing, their contact information. If you have text messages as evidence, we want that. Private messages from Facebook, all of it. If you've got evidence, we want to know about it. If you have witnesses, name, address, phone number, work number, email, Facebook, everything, we want to know how to get a hold of them. So your fact pattern report over 4 days is absolutely critical, and I could never stress enough the importance of a fact pattern report, because I started those the day after I had a client go, "Mr. Cobb, I forgot to tell you X." And X meant that guy would have gone to jail for a year. I undid a jury trial and instituted fact pattern reports after spending a lot of time in a pre-internet era going to the library studying a simple question that today would be a Google search, but you didn't have it back then. And the question was, what is the best way to gather information from a client? And to this day, most lawyers bring you into the office, their practice managers tell them to do that, never tell you anything you don't want to hear, do a lot of hand-holding, a lot of comfort sessions, so they can sniff out cross-sells, resells, and upsells, like you really need to be sold anymore in life. I mean, maybe it's just me, but I'm sick of going to the restaurant and they put the drinks down first, and they go, "Care for a drink? Care for an appetizer?" And, then there's the constant nagging for upsells. We can add this, it'll just be X number of dollars and cents. And then at the end, save room for dessert. At this point, I don't know about you, you may not even notice it, but I'm ready to scream. And you don't need that kind of sales pressure from your legal team. What you need instead are systems that work. And so fact pattern reports work. Now, in addition to a fact pattern report, we're going to get a discovery exhibit electronically from the Office of the State Attorney in one of the 20 circuits in Florida, depending upon where your case is. If you are the defendant, you will get a copy of this information. That's a discovery exhibit, whether you're in jail or whether you're out on bond, which we prefer. And we want you to go through all of this information. Now, I'll tell you right now, you're going to highlight things and you're going to note things, and we're going to look at it and go, "Yeah, that doesn't matter. Nope, that doesn't matter. Nope, that doesn't matter." Wait, what? That's important. Now, that's a big deal, because as you're going through the discovery exhibit, because you're not an experienced criminal defense lawyer, it's normal and to be expected that you're going to flag and highlight things that you think are important that experience has taught us, that's not important at all. However, I would rather you do your fact pattern report and make it 500 pages of single-spaced tiny print just to find one sentence that makes all the difference. And with your discovery review report, same thing. It doesn't have to be 4 days. Take your time with it, but I'd rather you highlight and take notes and write about 100 different irrelevant things that won't make a difference in the outcome of your case. But you might find 1 or 2 things that give us a motion to suppress a statement or physical evidence or other evidence that we would not have otherwise had. You're basically looking for 3 things in a discovery exhibit. You're looking for things that are true. That's kind of obvious. Things that are not true. That's blisteringly obvious. The third one is the most important in most cases. Things that are partially true. In other words, you're reading the reports and, you may be reading a witness statement and you go, that's true, whoa, 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 whoa. That's true, but they left something out. That's what we're looking for. That's where we often find defenses. So one of your responsibilities is a fact pattern report. Second is to do a discovery review report. And then as we're going through this list of things, we expect you to attend all appointments. That's absolutely critical, whether by phone or whether in person, whether it's at one location or another. We'll try and make it as convenient as possible, but we don't schedule appointments with you just to shoot the breeze. If we're scheduling an appointment with you, it's because you need to be informed about something. You may need to make a decision that will dramatically impact your life and those that you love. So this brings us up to the next area that I talk about all the time, to the point that it almost drives people crazy. And it's simply this: use the support materials from coping with stress during criminal prosecution. If you need a counselor to deal with the stress, get a counselor. Do not talk about your case, okay? But either way, you have to have a system so that you're emotionally attend at a time in life when it's the hardest. I mean, think about it. No one wakes up in the morning and says, I'm going to start a life of crime, I'm going to get arrested, I'm going to risk jail and prison, and I'm so excited about it, I can't wait to get arrested. I mean, that never happens. It's a disaster, and we fully recognize that, which is why we don't want you to be the guy who turned 4 years of probation into 35 years in prison because his mind was not in the right place. So it's absolutely critical, just as you are expected to do a fact pattern report and you are expected to review the discovery exhibit and to produce another report, just as you're expected to attend appointments and you're also expected to attend mandatory court as well, we also expect you to use coping with stress during criminal prosecution. Now, the next thing that's very important is we expect that you keep your contact information current, because we've had some people who just literally disappear, but all they've really done is move and change their cell phone number. We're trying to let them know there's a mandatory court appearance, and then we get a call a week after a bench warrant has been issued, and they go, hey, I just want to know what's going on in my case. Well, that's a simple answer. You have a warrant for your arrest and must turn yourself in. So keep your contact information current. That's extremely important. And then finally, if you're a defendant, your final duty is to make sure that your family controls stress, and we know how to do that.